Okay, well, it is week 8, and as I said to you during the open house, I said that the quarter would go very, 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 very fast. We are at week 8, and week 8 is one of the pivotal points in this course because if you will note from your written assignments that we'll go over this week, that since week 3, you have not had a project along with the written assignment. But from this point on, week 8, 9, 10, and 11, you will have your projects that you'll have to do. And a lot of times I encourage students, I said, make sure you get those because that's where you get a big portion of your points. We're talking about 400 points basically with week 8, 9, 10, and 11, and that can make a big difference in your passing or either getting a as opposed to a B, or getting a B as opposed to a C, or getting a C as opposed to a D. You know my position on C's. I don't talk about them. I encourage students to shoot for A's and B's and never ask me the question of what it takes to get a C in the class, because I said I won't answer that. I said that during week 1. So at any rate, let's go ahead and let's get started so that we can see what we got going here. And of course, my usual announcement there at the top about my phone number and all of that. Let's take a quick look at what we have for week 8. Insanity. 2 to 3 pages in length. You'll get a point for doing that. Explain the insanity defense and how it applied to Don, if it does. Identify what Don has to prove at trial to show that he is insane, if in fact he is. Identify what the government has to prove to overcome the insanity defense. In other words, to make him be culpable for the crime. And then your APA requirements, you get 3 points for that as well. So you don't want to miss. And again, APA requirements are citations and references, not or references, and then a cover sheet. And then you can lose a point for spelling or grammatical errors. Most of you lose points for not satisfying the APA requirements. Again, about reminder, APA format, and references that say that, yet still to submit. A lot of times they'll submit references but no citations. And then make sure that you do research and don't just use the textbook. Now, a lot of you have caught that point, so you will not lose points for that. Now let's go back down to the course project. So we're at week 8. Defenses. 2 to 3 pages in length. If not, if it's just 1.5 pages, you're going to lose 5 points. Because the theory is that it takes at least that much information to satisfy all of the requirements of this particular assignment. Explain the defense of stand your ground. You should know something about that already. Explain the defense of self-defense and justify use of force. Identify the various defenses that are applicable to the parties in the scenario. And then if you don't do the APA requirements, you will lose points. So, okay. And then again, reminding you that we have one more lecture to go. That's 2 weeks from today. I will be recording this one as I am now and sending it out to each of you. Okay. All right. So now there's somebody's mic that's open. You might want to mute yourself. I think I better go back. Let me stop sharing for a minute and go back, and I'll take care of that. So everybody should be muted. Yep, okay. So now everybody's muted. So let's go back to sharing the screen. Okay. So make sure you do those assignments. And then, of course, at the bottom, you already know your discussion post. You've been doing pretty good with that as well. Okay. So now let's go over and look at our announcement for this week. Defenses will be presented. This is like the defense attorney's favorite module. I was a defense attorney for many years in a criminal defense. I did other aspects as well, as you know, prosecution, police work, as well as paralegal investigations as well. So, but this was one of my favorites. This week you had just one chapter, chapter 14 of criminal law and procedure. And then take a look at the activity defenses to crimes, which we'll briefly look at. Discussion, stand your ground, which became pretty well known to people because of the Trayvon Martin case. I'll be commenting a little bit about that tonight. And then your written assignment, insanity, and then your course project, defenses that I just went over. And then, of course, the quiz. Again, I still encourage students to make sure that you do the quiz by the end of the week, after you've gone over all the materials that I've sent you, the PowerPoints, as well as the additional information that I send to help you to understand the material in the textbook even more so. And then my motto, you already know about that. Let's take a quick look at our course calendar. And this is where we are this week. Gives you reading assignments, gives you your initial post, remind you of the lecture that's taking place now, and your reply posts. And then, of course, your written assignments, your quiz, and then the course project due the 25th Sunday. I always remind students that if you really want to know what assignments, what it is that you missed, go back and look at, you can look at the module and you'll see what the requirements are for each of these. But you can also go on to the course calendar because it provides the same information as the announcement. It tells you what your reading assignment is. It tells you what your post is, tells you about the live lecture, and then it gives you a written assignment, quiz, and course projects. So that's one of the ways that you will find that. So now let's go down and let's look at the actual module. Again, repeating the assignments, in which Don defendant suffers from schizophrenia, and then it explains, and then he was charged with first-degree murder. 2 to 3 page paper addressed the following issues that are here. And then, as I already said, APA required, citations and references. Very, very, very important with a cover sheet. Your discussion post, this involves Travis and Christina and the force that takes place when Christina punches, what Travis starts punching Christina, and a fight ensues. And so anyway, the question is, does the stand your ground law apply, and to explain that. And so notice how it starts, though. Make sure you read the beginning part. Is that who started it? Who's the aggressor? Anyway, and then the Florida stand your ground law is applied here. This is, again, the law that was made famous in the Trayvon Martin case. And then your project for your 100 points is 2 to 3 pages. Discuss the various defenses and applicable, and pretty much be sure you discuss how these defenses, self-defense, whether it applies, justify use of force, and how the stand your ground law will apply to Alan and Betty, if so, involving this particular scenario here. Very important. And then, of course, your quiz. Okay. So that's the assignments for the week. Your course content, again, it lays out what we're going to talk about: self-defense. It tells you what you're supposed to read. It tells you defenses to crimes, which is just below here. Your written assignment that I just went over, and your discussion, as well as your quiz. Now, this does not show the project, but there is a project. You already know that. All right. So you should be aware of that, even if you look at this and say, well, I don't see it on here. They were supposed to put it on here, but it is not. But it is an assignment this week. All right. Because if you go back and you look at your assignment section under your assignment tab, you'll see it there. All right. That's a summary of it. So now these give some defenses to crimes. And these are possible things that you want to consider with your project. Capacity. I'm not going to talk about that too much because I'm going to be discussing that in a few minutes. Self-defense. Entrapment. And then you can complete the following activities. These are possible defenses, such as involuntary intoxication. And what is involuntary intoxication? Flip it over. A defense for a specific intent crime, if it negates the existence of the element of the crime. And then you can go to the next one. I'm going to do just one more. Okay. And then a defense to a crime, even though it does not negate the element of the crime. That's involuntary. Now remember, before, the first one was voluntary, not involuntary. So then there's some more after that. So I'm not going to go through all of those. You can take the time to go through those on your own. Okay. So I'm going to stop here sharing. And I am going to go ahead and share with you the PowerPoint that we're going to spend the next hour, probably about an hour or so. We may be adjourned before 10 o'clock tonight because there's only one chapter to cover. But this chapter is about criminal responsibility and what defenses are available. So let's delve right into it. Now, you're held responsible for your actions. It says criminal responsibility refers to a set of doctrines under which individuals are held accountable for their acts. And comes from English common law, as most of our law in the United States comes from English common law, except down in Louisiana, which uses the Napoleonic Code, France, and so it's based on French law. So it's the only state in the jurisdiction of the 50 states that uses that, but the other 49 based on English common law. So we provide possible defenses such as We did this for justifiable reasons, self-defense, mistake of fact. And what we're saying here is that we really shouldn't be held responsible for the act that we committed because of the fact that we were exercising, utilizing a defense. The Fifth Amendment furnishes what we call immunity defense. Immunity defense means that you don't have to testify against yourself. You know, the old Miranda warning, you have a right to remain silent. Anything can and will be used against you. But the Fifth Amendment directly states that you don't have to take the stand to testify against yourself. There have been many instances where I, as an attorney, elected not to put my client on the stand. And the reason why I would put my client on the stand is for maybe multiple reasons. One reason might be that my client has a background, and they can't cross-examine him or bring that background in unless he takes the stand and use that to discredit him or impeach him, as we refer to it as. Another reason might be is because I have a client that has what we call diarrhea of the mouth, which means they just love to hear themselves talking, and they will just go on and on. They'll keep volunteering information. In other words, they will basically have a shovel in their hand, they can grave for themselves, and they will end up saying things that even the prosecution doesn't ask them, so that they'll be volunteering information. So we won't put those kind of people on the stand as well. But then the Fifth Amendment says that if you are asked a question, you can also plead the Fifth by not answering the question, by saying, I plead the Fifth because it may tend to incriminate me. And that's an immunity form of defense as well. And oftentimes that's not usually done by the defendant. That's usually done by other witnesses that are called on to testify. And so you can't make them. You can't even use anything, because if they plead the Fifth, then they're saying basically I neither admit nor deny. And it's a constitutional right that you have under the Fifth Amendment. And then double jeopardy. Now, double jeopardy is very simple. It means you can't be tried for the same offense twice. Now, I want you to hear me good and hear me well. If you are tried in the state court for a crime, and the crime also fits the level of federal court, and you are not convicted in the state court, if you are tried after that by the federal court, that is not double jeopardy. It has to be the same level of jurisdiction. Double jeopardy is demonstrated. There's a movie called Double Jeopardy with Ashley Judd that I've seen, and it clearly illustrates the point of how double jeopardy works. And what happened is that Ashley Judd was charged with killing her husband and was found guilty of killing her husband and actually served time in jail. Well, she found out while she was in there that, in fact, her husband had faked his death and was living somewhere else with a woman who was really her close friend. How kind of friend is that? And anyway, the fact of the matter is he was still alive. And he had relocated. In fact, he was living in New Orleans. So anyway, she ended up tracking him down and finding him when she was released on parole. And Tommy Lee Jones, I think, was her parole officer in this movie. And she ended up finding her way down to New Orleans. And she confronted him. And after that, he tried to get rid of her. He tried to kill her a couple of times. Well, anyway, the movie ends with her actually shooting him and killing him. Now, one would argue in the situation, if you see it, that it would be self-defense. Well, it probably would be if it had a trial. But double jeopardy creates the position that there is no need for a trial because it comes first, because she's already suffered jeopardy for a crime that she didn't really commit, but that she served time. So therefore, when she killed him, even if it wasn't in self-defense, it would be considered double jeopardy to try her for his murder, and she was able to go free. And that's pretty much how double jeopardy operates. So the key thing is that if you have been found guilty of an offense, and you've been found not guilty, and then you're tried in a federal court after trying to state court. But if you've been found guilty in the federal offense, and then you get out, in the state offense, and you get out, and then you find the person, as she did, and actually commit a crime, then because double jeopardy says you can't try that person for the same crime twice, you would be let free. And that makes sense, because what you're doing is you're giving the prosecution 2 bites of the apple, and that's not the way our system works. Negative defenses versus affirmative defense. In a negative defense, you deny you committed the crime. In other words, you weren't there, you might have an alibi, or either you're saying that you didn't prove your case beyond a reasonable doubt. And so basically, pretty much the biggest negative defense generally is an alibi, or indicating that the individual that they are prosecuting is the wrong person. Now we have DNA evidence which can help to exonerate individuals, things of that nature. Let's say, for example, fingerprints are found, and it's someone else's fingerprints and not the individual's fingerprints, and then they find out later that DNA of that person matches it. So their affirmative defense is an alibi. No, I didn't do it. I was somewhere else. I didn't do it. Affirmative defenses, on the other hand, defendants admits the crime, but denies that they're responsible for it, such as there was an excuse or justification. Self-defense is, or stand your ground law, which means that the law protects them because they were protecting a person, or protecting themselves, or protecting their own property, or some situation like that. Or the defendant had some mental capacity issues, insanity, and didn't have the capacity, or even a minor, which we're going to talk a little bit about that, to commit the crime. And so they were underage and could not be held accountable for their criminal act. So their capacity to form criminal intent was not established because they weren't mature enough. But the defendant, if you're going to do this, has the responsibility of proving that defense by a preponderance of the evidence. Now, the key thing here is that you're saying, yes, I did it, but I did it because. For example, I represented a young man who, many young men, but one of my first cases, a double murder case, young man was charged with killing 2 guys. He shot them, and there's a lot of factors involved there that really I won't go into, but the fact of the matter is that right off the bat, I presented my defense admitting, yes, he shot them, and that he did it because they pulled guns and announced they were robbing. So he had a gun and he shot them first. So the jury found him not guilty because I made my burden by proving very successfully to them that he was simply defending himself and the others in this game. It was a crap game, but you know. So, but anyway, the bottom line, that's how affirmative defenses work. Okay. Now, here we go with an affirmative defense: lack of capacity, such as infancy. Children under a certain age are not able to form criminal intent. Under common law, the age was set at 7. However, that was before we had juvenile courts. So now, since we have juvenile courts, the age limitation has changed. So with the development of juvenile court, age limitations have decreased. Therefore, I don't know if it's 7, but I know it's at least 12 years old that a person can be charged with a crime based on their age. But there are certain things in the juvenile system that are not available to them, like jury trials and things of that nature. And then in the juvenile court, our idea is not to find them guilty, but to adjudicate them. And then our primary goal, which should be the primary goal in criminal cases, is to rehabilitate. However, though, with juvenile court, that is right off the bat the thing, because there's a Latin phrase, parens patriae, which means that the court stands in as parent of the child to, how should I say, discipline that child, but not necessarily leave that child with a record, which is why juvenile records are sealed and oftentimes not able to be used except in situations where there's high clearance necessary for a certain position, maybe a government position, Homeland Security, FBI, CIA, Secret Service, those kinds of things, and maybe in some other instances. But the point of the matter is the main goal is to rehabilitate the individual. And then under certain circumstances, as you know, children are tried as adults. And one of the reasons that's happening is because, as we all should know, that there are more and more juveniles committing serious offenses, a lot of gun offenses, drug offenses. I'm talking about big drug offenses. However, though, just remember, with the drug offenses primarily, we're still working to try to help those individuals, because here's what you should know. Most juveniles who commit felonies, even carjackings, adults use them to commit the crimes, knowing that those individuals will either get a slap on the wrist or a light sentence. So therefore, they will utilize these individuals. But the key thing is that the infancy defense is really not as prevalent as it was now, and it's rarely used. It's rarely used. And then they talk about children being tried as adults. The youngest person who's been sentenced to life, for example, was 13 years old. And many children tried as adults for violent crimes were exposed to violence, and current law ignores the social problems that cause these crimes, and pretty much these individuals are tried as adults based on the serious offenses that are committed. Okay. Intoxication. Now, I talked about this earlier. Voluntary intoxication is never, and I say this is not typically, I've never seen it used as an excuse defense. I did this because I was drunk. You might use it for mitigation, but it depends. But that could come back and haunt you. When I say mitigation, saying that, well, if I wasn't drunk, I probably wouldn't have committed this offense. I wouldn't have been involved in this accident, or either I would not have done this thing, raped this person, robbed this person, stole from this person. But the key in this instance, if it's voluntary, that means you took the drink yourself. In some states, it determines whether or not specific intent takes place, and it might help you a little bit, but not a whole lot. What our general thought is, as defense attorneys, is that voluntary intoxication is not an acceptable defense in most of the cases. And most courts, as it says, rejects this for general intent crimes. Involuntary, on the other hand, is when someone slips something on you, or you do it unintentionally. Let's say you take medication and you didn't realize the side effects, or either you double took your medication without realizing you had taken it earlier and then you take it later. In those cases, it removes criminality from the act. But you have to be able to make a good case that it wasn't done on purpose in those kind of situations. Some have argued that alcoholics should fit in involuntary intoxication, but most courts that I know treat it as voluntary intoxication, but will use it as mitigation, the alcoholism or either addiction, to not give them as very serious a sentence, but instead get those people some help by getting either some drug treatment or either some alcohol treatment, whatever for those. But the key thing in terms of this, since we're talking about defenses, involuntary intoxication is more of a successful defense than voluntary intoxication. Because with voluntary intoxication, you knew what you were doing, or should have known what you were doing. Insanity, okay, I will say this, that I have represented people down through the years, from 78 to 2000 when I retired, and I had some cases that people committed offenses which I would use as attempt to use insanity. We would file a motion for medical examination from a psychiatric point of view and have the psychiatrist examine them. But in Illinois, it is a very difficult burden to meet. I never had a person that was mentally ill by the standards under the law. And I'll elaborate on that in just a minute. But let me just tell you a little bit more about insanity. The degree of mental illness that has to take place that says you don't have the capacity to commit a crime, or that you're not responsible for the act. Now, there are several tests. The Norton rule, which says this, that at the time you committed the act. Now remember that at the time you commit the act, the person was suffering from such a defective reason that they did not know what they were doing was wrong. In other words, they were out of touch with reality. I don't mean from alcohol now. Remember, we're talking about a state of mind. Maybe schizophrenia, maybe not. It depends. But I can tell you this, that if a person argues that at the time they committed the offense that they did not know they were doing was wrong, there better not be anything that demonstrates that they're covering up anything. And the Norton rule also irresistible impulse. In other words, it's beyond my control. The Durham test says you have a mental disease or defect that wasn't addressed, and therefore that's why you committed the crime. So let me go through the next slide, and then I'm going to talk to you a little bit about one of my cases that I tried to do it that really was a very interesting scenario. But anyway, the ALI standard, which is we call the substantial capacity test, pretty much basically wipes out any possibility of insanity for anybody. Everybody's saying when they commit the offenses. On federal law, Insanity Defense Reform Act of '84 said that psychiatric evidence of impaired volitional control is not admissible. Psychiatric evidence, though, could be used to negate specific intent. So in other words, this was an attempt to do away with the insanity defense altogether. So as I said, it's a defense is hardly ever used. Clear and convincing evidence standard, the burden of proof, of course, shifted to the defendant. They had to prove that that's how they were at that time as with a affirmative defense. Some states have abolished the insanity defense, but there are still remnants of it around. Now, here's an example. Eric Clark was charged with killing a police officer. He said that he was insane since he was suffering from paranoid schizophrenia. The Arizona law, the state of Arizona, which is where this occurred, did not include part of the Norton rule, which stated the defendant did not understand the nature and quality of the act, and he was convicted. He appealed, and the Supreme Court ruled that the Arizona statute did violate his due process rights, and that states may refuse to allow psychiatric testimony short of insanity to negate mens rea requirements, but that they still have to consider he understand the nature and quality of the act. That was the law there in terms of that. So it's an example. Now, before I get to this, let me go back. Let me tell you about a situation here. I had a young man I represented. This is one of my last serious cases right near the end of my career. I think I started the case in 90, 99, 98, and finished it right at the end. Anyway, this young man was charged with murder of a meter maid. And the meter maid came to the house to, not a meter maid, but was a utility. I think it was People's Gas, because, yeah, it was in the city of Chicago. Anyway, the person came to cut it on. And that the young man, who was 17 at the time, he basically said in this statement that she bent over to light it, and he said he observed her butt, and she was dressed and everything, and he just lost control. He immediately got a knife, forced her to undress. He raped her. Now, after he raped her, he tied her up. Then he took the knife and started sticking her and said, "Don't tell, right? You're not going to tell?" And she's not going to tell. She said, "Yes, you are." And he kept sticking her and jabbing her with the knife, and the blood just came out, and then he just kept. And so she died. Well, after that, he took her body, rolled her out, got her out of the house, put her in a garbage can, and took the garbage can out of his garage and rolled her body about a block or two away and left it in an alley. And after that, he was arrested. And so I got the case. And so one of the issues that I had to pursue was this young man had a clean record. He had never committed any, he hadn't even had any problems at school. He was an upstanding young man. You know, he had no problems with anybody. He was a member of a church, an active church. But he said he simply lost control. So as a requirement, I filed a motion to have him examined by the psychiatrist. And the psychiatrist came back and, of course, ruled that he was not mentally unstable at the time he committed the offense. One of the things that did him in, as I said this earlier, is that when he killed her, he tried to cover it up. He put the underwear under his mattress, which was later found, and all the different things he did after. So that right there negated the defense, but I still had the obligation to file the motion to see what the doctor would come back with. And I wasn't surprised when he came back saying that he was not insane at the time of the offense. It might sound insane. It might even sound crazy. You know, the guy took the body and put it in the garbage can, rolled the garbage can. By the way, the garbage cans are all serial numbered, and the serial number on the garbage can that was a few blocks away went back to the address where the offense happened. which was the last place that the young lady went to before she was killed. So anyway, and then there was no DNA at that time. None of that stuff existed. But anyway, the bottom line was there were pictures. There were all kinds of evidence. So I ended up trying to plead him guilty. He didn't accept my deal, and ended up, we went to trial, and then of course he was found guilty. He was sentenced to natural life. He was not executed, and the reason he wasn't executed is because of something we talked about in week 6. Even though Roper versus Simmons didn't exist, which said that we don't execute juveniles, but in our jurisdiction at that time, the law was still in place that if you commit an offense and you were a juvenile, which meant you were under 18, you could, the longest sentence you could receive was natural life, which is what he ended up with. So anyway, just showing you. Now, here on the other hand, let me give you an example. We came to the conclusion, as we lawyers called it in Illinois, the Amanda Wallace rule. Now, let me explain the Amanda Wallace rule. There was a lady, and she wasn't my client, but she had a child, and the Protective Service Agency in Illinois called Department of Children and Family Services, or for short, DCFS, took the child away. However, they gave the child back to her. And a short period of time after she got the child, she ended up hanging that child. And the child died. And after that, of course, she was arrested. I saw her in the lockup. I was visiting another client, and I knew she was because I had seen it on her on TV. Anyway, and she was sitting in the corner, and she was like rocking. I mean, she was literally, she was like, if you saw her, and you saw the look in her eyes and everything. And so, long story short on this one was, it was determined that she was suffering from paranoid schizophrenia at the time of the offense, because when she hung the kid, she thought that she was hanging an animal or a pig or something else. And so therefore, her defense of insanity was successful. So we started saying, well, the only way you're going to really get somebody insane is using the Amanda Wallace test. So what am I saying in summary before I leave this topic is that it's a defense that is hardly ever successful. Now, it might be used in what we call a diminished capacity, which means that it might cloud your judgment, same way as alcohol or drugs, whether they're voluntary or involuntary, but it is not adequate enough to provide complete exoneration or be used successful as a defense. Pretty much that's it. However, we lawyers still have the obligation to our clients that we still have to file the motions even though we know how they're going to turn out, because we don't determine what the doctors might come back with, but we pretty much know. So that's that. Go back. So some excuse defenses. Here's what people use as, I did this because I was under duress. Now, we say to people that if you're going to use duress as the basis, there must be what we call gun at head duress or immediate duress or immediate danger. It says here the use of illegal confinement or threats of harm to coerce someone to do something they wouldn't otherwise do. Like, for example, threatening to kill a family member, and it's imminent. Not that the member is far away, that they might even have the person kidnapped, or they might have them, or have access to them. In that kind of situation, the crime that's committed, the individual could use duress as a defense. Necessity. Forces beyond the actor's control. And in other words, I did this because I had to do it. Well, it's not really like self-defense. But what we're saying is that I had to do this to survive. Economic duress has been not accepted. In other words, I committed this crime, like I stole this loaf of bread because I was hungry. I did this because I needed to eat, or either I robbed this person because I needed money to pay my rent or to pay a bill. No, no, it was that's these are some defenses that people try to use. You'll be surprised. I've seen them, and not very successful. Consent. Physical injury consented to must result from conduct that is not intended to cause serious injury. Not very successful most of the time. And like for example, that used to be a defense that was commonly used in rape cases, that the person consented to it, and that and then that the person went so far and then they didn't stop. Well, like I said again, usually consent defenses are not very successful defenses. Mistake of law. Don't even try it. There's an old adage that's written here: ignorance is no excuse. You misinterpreted the law. No, it's not going to be a successful defense. But these are defenses that people have tried. I didn't know. Well, it's not whether you know or not. The law of the land is the law of the land. Mistake of fact. Innocent misunderstanding rather than from criminal purpose. I made a mistake. I accidentally did something. Well, the point of the matter is this. If the offense that you commit reaches the stage or level of a criminal act, mistake of fact is not going to be satisfactory. Now, it has been used, for example, in situations where persons have taken the wrong property from someone. They thought it was theirs, or either there's been some dispute about the property that ended up possibly in court. In those kind of situations, it was a mistake of fact. But not very, these defenses on this page, I never had any of these I ever used, because we always were taught in law school that these are what they call novel defenses, but that in most jurisdictions, they don't go very far. I know in Illinois they don't. In Lambert versus California, the Supreme Court reversed his conviction based on the notion that the defendant must be notified of the act. In other words, this person was convicted of failing to register with the city as a convicted felon, but he never got notice. So he appealed his conviction, stating that his due process rights have been violated, and the court says yes. So if the person reasonably should know a situation and then they do it, that's a different story. But in this instance, the city, or there should have been a requirement given to him notifying him that as a convicted felon he had to register in any city, and if he was not given notice, then he didn't have the right to, he didn't have the opportunity to know. It wasn't strict liability at that particular time. Laws now might have changed because of the strict liability laws. When I say strict liability, you guys should be familiar with that, but just a reminder, it means that it doesn't matter whether you knew at the time of the offense. There's no mens rea, no criminal intent necessary. All that the prosecution has to prove is that the law existed and that you failed to satisfy the requirements of the law, period. So we get to one of the biggest areas, use of force and self-defense. So we get to the point of saying that, in essence, the force that is applied must be commensurate with the force that you're meeting. Let's say, for example, if I raise my hand to hit you, and you hit me with a weapon or a gun, shoot me, or a knife and stab me, or pour some kind of caustic solution on me, then that's excessive, because the force that I was using was to strike you. Now, if you struck back with your hand when I struck you with my hand, then there is the use of force issue would be okay. You have to use the necessary force. So then the question comes, when do you use deadly? Well, again, back to what I said earlier. It has to be a situation where you're placed in a death situation that you use deadly force. If you use deadly force and you were not placed in a situation, or a loved one not in a situation, then the question comes about. I know of a case that I had a young man that I represented some years ago who was in juvenile court. I remember this. The man who was her boyfriend, his mom's boyfriend, was beating her up real bad. And he grabbed the guy, and he took the guy and threw him out of a third-story window, and the guy died. So my argument was that he was responding to seeing his mom being hurt real bad, and that he took steps to protect her, and that his adrenaline and everything caused, because the window wasn't that far away, and that he threw the guy. So it wasn't no video or nothing like that. But anyway, that's basically it. Well, he was found guilty because he did that. What they said that should have happened is that he should have used force to hit him, maybe even hit him with a piece of wood, or if he just stabbed him, because the guy that did it, my client, was not a big guy, and the other guy was big. So in that case, so he ended up, in juvenile court, and so he ended up with a short sentence. But you can't use deadly force in a non-deadly situation. So if it's a non-deadly situation, you must meet with the same kind of force. Self-defense is an affirmative defense. Remember, it's saying, I did it. I earlier stated that mental capacity was a negative. In fact, it's really an affirmative defense. But affirmative defense says, yeah, I did it, but I did it because. And so here's the stand your ground laws. With the stand your ground laws, you have to be in a place where you're supposed to be, and you have to use the level of force that was used against you. Say, for example, if somebody grabs you and pulls you and snatches you, and you turn around and you can push them or hit them back, not with a weapon or a gun or anything, but with your own hands, then it would work in the stand your ground laws. A little hint for you. Retreat. There used to be the argument that you had to try to retreat first. In other words, that you were cornered before you exercised self-defense. But that rule has been pretty much shot to the wayside, and I'm glad it did, because it didn't make much sense. In other words, you had to try to escape. But no, time would be of the essence. Let's say, for example, somebody pulls a gun on you, and you try to dodge them. That's not going to work. But you got a gun and you shot them like my client did. Well, then it wasn't necessary for you to retreat, because time is of the essence. So it is an affirmative defense, but it must be commensurate with the force that you face. Objective test versus subjective. It's based on a case-by-case basis of all the surrounding circumstances, and pretty much you can determine. Now, here's some possibility of uses of force and self-defense. Now, battered women. Oftentimes, the battered women defense of self-defense is utilized in domestic violence cases where individuals have been beaten by their partners many times. I had a young lady that wasn't my client, but we grew up together, and then the family called upon me to review her case after she had been found guilty. And what she did was this. She had been beaten many times by her husband, but she waited for him to go to sleep, and she got a gun and shot him several times. Well, that right there was not good, because she had a way to leave. But we understand what would have happened is that she would have been tracked down by this guy. He would have gotten her, and then she'd been back in the situation again, and ultimately could have caused her death. Now, the battered women defense works very well when it's a simultaneous situation where a person gets something and they're being beaten, and then they end up killing that person. It works well there. But in the scenario like the one I talked about earlier, it's iffy. It depends on the jury. It depends on how the lawyer presents it. I believe that I could win every battered women case that I ever had. And I didn't have any, but I looked at some. I reviewed some, and I saw a way to do it. The key thing, especially in the time that we're in today, with all the things happening, with the sexual issues that are coming out, battered women cases would be easier to win with juries, not with bench trials, but with jury trials. The child syndrome, that means that you were, in my case here, let me give you an example. I grew up as a kid. My dad was killed in front of my face by the guy that didn't go to jail, turned out to be my mother's live-in boyfriend. You go back to the open house and you'll see what I'm talking about, because I gave all the facts about why adversity springboard success is my motto. But anyway, I grew up in the house where the guy didn't go to jail, but then after that, before 57 up to 63, I lived under constant observation of my mother being beat, constantly. And as a result, then he ended up killing her some years later. But here's what I'm going to say. A person like myself and my siblings who would get themselves in criminal situations could argue the child syndrome because of what we saw over and over and over and over again, and as a result try to use that as self-defense, as a basis for why we would do something. Well, the bottom line is that some say yes, some say no, but it has been used in those kind of situations. The one that I was telling you about, the guy that beat the kid's mother, and then he threw out the window. This was a series of beatings that he had lived. Enough was enough. And I did try to use the syndrome that he was driven to that particular point. The juvenile court, remember, it was not an adult court. The juvenile court, the judge said he understood, but that he still found him, adjudicated him delinquent. But that when the sentencing came, that's why he got a lighter sentence. That's the point I'm bringing out to you. So it was used, as we call, a mitigating factor in the sentence that he ultimately would receive. So, and that's what happens to a lot of times with the child syndrome, is that it's used as a mitigating factor as opposed to a complete defense that excuses your actions. Defense of others, I already talked about that, and defense of property, I talked about that as well. Okay. Now, here's the stand your ground law. I already told you. I said that, 2012, really close to the time here that we are now. Zimmerman was working as a neighborhood watch, shot Trayvon Martin. Zimmerman claimed that he had been charged by Trayvon Martin and that his life was being threatened and he acted in self-defense. Zimmerman, in fact, had watched Martin walk in the neighborhood and called the police report that he was acting strange, whatever that means. Unfortunately, the young man, when he found him, didn't have a weapon on him. He had some Skittles, and he had a drink, and not alcohol. It was a soda. So the police told him to stay away. Now, that right there is a point of contention for most of us as defense lawyers, lawyers that look at this and say, wait a minute, he was told to stay away, but instead he ignored the police and approached him, and he was charged with second-degree murder. Well, the point of the matter is that here's the deal, is that he was found not guilty. But the point of the matter is this, is that we think, first of all, number one, that the prosecution should have charged him with first-degree murder. Secondly, that he was doing something that he shouldn't have been doing because the police told him to stay away. But under the law and the jury, he was found not guilty. So we have to just explain that. But be aware that the stand your ground law came into debate. So the question to date is whether he acted in self-defense or murdered Martin. And from my perspective, he murdered him. But some people say that the young man was doing something. But once again, there was a tussle and a wrestle. But the point of the matter is this guy is doing something that he was told by the police not to do. And so that's the whole argument in a nutshell as far as me as an attorney or prosecutor looking at that. So that's what the stand your ground law is and how it became famous. There's various forms of immunity. Constitutional immunity, I already kind of talked about that. Privilege against self-incrimination, in other words, you don't have to testify against yourself. Immunity can be transferred to a witness where the Fifth Amendment can be pled, or that the individual is going to testify, but they're not going to be held under agreement. They're not going to be held responsible for the criminal activity that they did. Usually that's done if you want to get what we call the big fish, and they got what we call the small fish, get them to admit, and then they will basically roll over or flip or rat on the other party. So the constitutional immunity takes place. Other forms, contractual immunity, where witness protection, also in the same scenario where that person actually says they did it, but that they're using them, they made a deal. Diplomatic immunity, that means that you're, for example, I'll give you an example in the next slide. You are a dignitary of another government or something like that, and you commit a crime. Legislative immunity, which means that because your position, the executive privilege thing that President Nixon tried to invoke, and it may come up again with the current president, but where because of your position in the law that you can't be prosecuted for a particular crime. Now here's an example of diplomatic immunity. Protects government officials in foreign countries. On January 27th, U.S. diplomat killed 2 Pakistanis. He admitted to shooting the 2 men after they pulled alongside him on a motorbike. The American officials said he said that he saw they had a gun and thought he was about to be robbed. Well, the Pakistan government charged him with double murder, ignoring his immunity status because he was a foreign diplomat and should not have been tried under diplomatic immunity. He was released from custody after payment of $2.4 million. And so then the whole question is about, what do you think about diplomatic immunity? Is it fair to exclude diplomats from prosecution? what if a Pakistan diplomat had killed Americans? Would you want him prosecuted? The point of the matter is the diplomatic immunity should work either way. But it basically means if you commit the offense and you are a foreign dignitary, that you're not going to be tried here. You might be tried back the country that you are a diplomat from. I already talked about double jeopardy. And then said it does not exclude prosecution in state and federal court. Doesn't apply to a mistrial or acquittal, of course. And the Blockberger test, I already talked about that you can't be tried for the same thing twice. Same evidence test, same evidence, same elements test. I already talked about that. Statute of limitations is another possible defense. Says that you have to be tried for a particular crime within a certain period of time. There is rarely a statute of limitation for murder. That's why people are sometimes tried years and years and years later. And they give some guidelines, 5 years for non-capital offenses in federal court. But each state has different limitations. And then some states have removed limitations for rape, and as you probably know, because people are coming forth many, many years after. And the reason they did that is because rape is a crime that used to involve some very serious issues with the person who was the victim until the rape shield laws came, which we talked about during week 6. But defense can waive the right to the statute, and if they need more time. In other words, the statute of limitations, you can't like stretch it out while you're preparing for trial and the statute of limitations runs. No, it starts to run, and then if you want to extend the time, it'll stop it until you finish doing what you're doing, then it'll start back again. Governmental misconduct, entrapment. This means basically that you, an individual, will mind your own business, and someone from the law enforcement walks up to you, for example, and you're walking down the street. They know you. They maybe know you or don't know you, but let's assume that they know you. They know that you smoke weed, and then they offer you, some weed, and then you say, yeah, you want to buy it. In that case, the government agent induced you to commit a crime that you would not otherwise commit. They say, yes, you would, because they say you've been known to smoke weed. Now, that case you were not smoking weed, and they provided it. It's a difference, though, in a sting. A sting is where you voluntarily come, and you know what's going to happen, and you're part of, the planning. Or you're a customer and you know what's going on, and it turns out to be an undercover cop. That's not entrapment. But entrapment is something that takes place now. It wasn't originally a common law, and it's not in the Constitution. But it basically is tried on a case-by-case basis to determine what is and what is not. Some of gross entrapment is when, like I said, the one I gave a few minutes ago. Here I am. I'm walking down the street. I don't mess with that kind of stuff. But and if a person said, yeah, you said you wanted it. I said, no, I don't. I never do that, and I'm minding my own business and going about my way. But let's say, for example, again, as I said again, a person that they don't know, and then the person decides to do it. In that case, because they planted the idea in the mind of the person at that time. Maybe they were going to, but that wasn't something that they had arranged with them. And in that case, it's entrapment. And a motion can be utilized by a defense attorney to throw out the evidence. United States Supreme Court in Jacobson reversed his conviction for solicitation of sexually explicit materials. Now let me show you what happened here, and it fits what I just told you a minute ago. Jacobson's conviction for solicitation of sexually explicit materials, arguing that the government agent could not implant a design in an innocent person's mind and then induce them to the commission of the crime. That's what I said earlier. But here's what happened. Jacobson, he was a convicted sex offender, but he was targeted by police and received mailings of sexually explicit material over 26 months. The mailing also included communications decrying censorship and questioning the constitutionality of the government's efforts to restrict sexual explicit materials. So what they were doing was they were putting it in front of him. They knew he already was a convicted sex offender. So what they were doing was, it's like catching a mouse in a mouse trap. And you put what they like in that mouse trap, and that person gets caught in the trap. That's the same thing here, and that's one of those clear cases of entrapment. And you can't target this individual by utilizing the weakness of that individual. That's what they basically try to do, and that's a case where the lawyer was very successful with getting the information, getting the conviction overturned. Selective prosecution, where people are singled out on the basis of race, religion, sex, national origin, or other classifications. However, though, you must be able to prove that other similarly situated individuals have never been prosecuted, very rarely used, typically rejected as a criminal defense. Usually this goes into civil cases, but not in criminal cases. So in other words, here's the deal. I'm going to give you an idea. When I was the village attorney in a town called Ford Heights, we have people who come to court, and they would say that everybody was speeding, and they got caught. So they said, well, you only got me. Well, the person wasn't caught because of their race, religion, or other impermissible classification. They just were the ones that got caught. But they tried to argue that there were other individuals who had not been prosecuted for the same conduct. Well, it wasn't successful. It wasn't successful. It's almost like the same one, or people would oftentimes try to use what we call the 5-mile rule, where defendants would come into court and say, for example, the posted speed limit was 25 miles an hour, and they came in and asked the question, what was your speed limit? What was the speed that you were doing at the time? 30 or 29. And then they'd say, okay, you've admitted that you violated the speed limit. They said, well, no, what about the 5-mile rule over the speed limit? There is no such rule. And people think that and thought that for many years, but there is no such thing. And what that person basically did was admitted that they violated the speed limit. So anyway, that's how that works. In Wright versus United States, the Supreme Court held that passive enforcement of prosecuting only those non-registrants who reported themselves or were reported by others was not a violation of the First or Fifth. This person hadn't registered under the Selective Service Act and was convicted. He argued that there was so many other people that hadn't been prosecuted, almost like the same thing I said earlier. And the court says, nah, that's not going to be. You got caught and you're being prosecuted. Maybe we'll get around to the others, but you did violate the law. And that's an example of what I was talking about a few minutes ago when people say that, oh, everybody was speeding. And then finally, we complete with some novel and innovative defenses which don't really carry weight. Failing to obtain a medical treatment for a child due to religious beliefs is not a valid defense. In other words, it's my belief that my child should not be treated by a doctor. The law says that's your choice, but you can't do that for the child. The child is entitled, and if you don't receive medical treatment for that child, then you are violating the law. So you can't use your religious belief. The victim's negligence, the person who you committed the crime against was negligent, not gonna fly. You had premenstrual syndrome. It's because of the time of the month that I was dealing with. I was under so much stress. That's why I committed the offense. It might be used for mitigation, but it's not going to be used as a defense. Compulsive gambling. I can't stop myself. I should be in Gamblers Anonymous, but that's why I keep doing these crimes, because supporting my gambling habit, that's why I stole that money. It's not going to fly. Not going to fly. PSS, post-traumatic stress syndrome, same thing that falls under the premenstrual syndrome, not going to be successful, could be used for mitigation, but not as an absolute defense. The old infamous junk food, because I eat so much junk food, and I've heard that. I've heard people say, man, it's what you eat. It turns you into a criminal. Well, okay, it's not going to happen. It's not going to. You're not going to be successful with that. You're the one who ate it. You're the one who decided it. You may have been depressed and you kept eating, and then you went out and did something. It's not going to fly. I've never seen it successful. TV intoxication. You watch so much violence and crime on TV that you thought you could do it. Not going to happen. Not going to happen. Pornographic intoxication, same issue. You are addicted to pornography, and so you're going to go out and you're going to commit a crime of rape or something like that. Not going to happen. Chromosome abnormality, XYY, absolutely, positively, without a doubt, no way, buddy. You're not going to be successful with arguing that as a defense. You're going to go down every time, okay? If you're going to talk about this, it's in the genes. Well, guess what? You're going to go down, and you're going to end up find yourself in a situation where you are going to end up going to jail. And so that's about it for today. I do want to remind you of what we talked about earlier with your written assignments. Make sure you get them completed on time. Like I said, we're going down to the end. We got, after this week, we got 3 more weeks left, 9, 10, and 11 weeks. So with that, unless you have any questions, if you have questions, you can type it in the chat box. And I'm looking at the chat box, and I don't see any questions. And if you do, give you a couple seconds. Okay, well, I don't see any, but if you do have any questions, you know how to reach out to me. I've already established a rule on any hour of the day except the 25th hour of the day. All of my students, I meet them years and years later. I always ask them, do you remember the time when you can't reach me? And they said, yes, Professor, the 25th hour of the day. So with that, I'm going to say good night. I'll see you in 2 weeks for the final lecture. Good night.